Okay, Katie, I think we are gonna go ahead and start now. Hi everyone, thank you for joining. This is Hiring in a Post-Brexit World. My name's Molly, I work in marketing at Bespoke. I'm sure I've probably met all of you before at our previous events, but I just wanted to say thank you for joining. So we've got Katie today from H&P Associates, and she will be taking you guys through everything to do with the Brexit changes and how that will affect you guys as practices and what you need to be doing going forward. Just a few pointers for this webinar. If you have a question, please just pop it in the Q&A box and I can put it to Katie to answer. And if you have anything you want to ask me or ask one of our consultants, then please just get in touch afterwards. I believe you should all have my email address, so if you'd like to drop me an email, then I can pass it on to the relevant consultant. And one last little plug, that our new Global Salary Guide for 2021 is out now. So if you'd like to request a copy, please just send it over to me and I can make sure you get one. And with that, I will pass you on to Katie.
Thanks very much, Molly. Good morning, everybody. Thank you very much for inviting me to speak to you about what's happening in the world of immigration post-Brexit. Hopefully this discussion will give you a bit more clarity on what's going on from immigration and in terms of what you need to be looking out for. Obviously with the pandemic that's going on, you know, the world's turned itself upside down, but eventually we will be out of lockdown and life will come back to some form of normality. So I'm going to take you through our agenda for this morning. I'm going to give you an overview of Brexit and implications. I'm probably telling you what you already know, but I'll give you an overview nonetheless. I'll talk to you also about, as a result of Brexit, the European applications that need to be made under the UK rules for EU settlement. I'm going to give you an overview of various immigration routes into the UK and routes into the UK where sponsorship isn't required. I'll talk to you about sponsor license applications briefly in case you become an employer that wants to sponsor overseas migrants. And then I'll take you briefly through compliance, duties and responsibilities in terms of prevention of illegal working, which you probably already do now, and also right to work checks. So it'll just be an update on what you should and shouldn't be looking out for. So to get the ball rolling, let's talk about Brexit. So the biggest implication for employers is the limited talent pool that you now have. So you've gone from being able to look for suitably qualified professionals from 27 countries to 2. So obviously that's going to have an impact on your ability to find the professionals you need for your business. It does, however, mean that you've now got 195 countries to look for individuals to come and work for you. Post-Brexit, obviously the Home Office have introduced a new immigration scheme, which basically isn't that much newer from the old scheme, they just rebranded it. So from the 1st of January, any employer wanting to employ any EU national to come and work in their business, if they're not already here, you'll have to sponsor them. That's going to get quite expensive. A typical cost for an application under skilled worker sponsorship is around £5,500, and that's just the Home Office fees. That doesn't include any fees if you instruct an outside counsel or immigration firm to assist you. So that's pretty much it in a nutshell. The talent pool has gone down. Sponsorship is required for any EU nationals now. And then obviously you can look globally, but you know, you're going to have to sponsor them under the work permission route. I will talk to you about the various routes where sponsorship isn't required, but for the purposes of this webinar, we're going to be looking mainly at the skilled worker route and the intra-company transfer route for you if you're part of a multinational organisation. So let's talk about European applications under the EU settlement scheme. So the scheme itself opened on the 29th of March 2019, and the purpose of the scheme is to bring all EU citizens currently residing in the UK under UK immigration rules. When we were part of the EU, there wasn't any requirement at all for EU nationals to prove that they were exercising their treaty rights to live and work in the UK. A number of EU nationals did get EEA residence documents certifying permanent residence, but it wasn't a mandatory requirement. Now that we've left the EU, it is a mandatory requirement, regardless of how long you've been here, to come in under UK regulations. Now, there's a grace period for any EU citizens that haven't already applied for either pre-settled status or settled status until the 30th of June, and they must have applied by the 30th of June. If they don't, and they've been living here for 20 years, the scenario could be that they go away once we open up and they go home for a holiday, and then they look to come back to the UK and they can't provide evidence of their immigration status. They could be refused re-entry by border officials. So if you've got any existing EU employees working for you, and I apologise for the phone, hopefully that will cut off eventually. If you've got any existing employees working for you from the EU, it would be worthwhile just sending a communication around saying, if you haven't already, please make an application for pre-settled status or settled status. If you've got any employees that are in the UK that have blue residence cards that show that they've got a right of residence, they also, unfortunately, will have to apply under the settled status scheme. Those residence cards were issued under EEA regulations and are no longer valid. It's not an automatic process to be able to say to the Home Office, I've got a document certifying permanent residence under old regulations. They're no longer acceptable. Obviously, the settlement scheme isn't required for Irish nationals. It is free, however, and it's a reasonably straightforward process, and I'll take you through that as we go forward. So this is a copy of a typical document certifying permanent residence for members of EEA states. If you've got anybody in your company that holds one of these documents, then they will have to make a fresh application under the new UK immigration rules to apply for settlement. So again, worthwhile just sending a communication round, just double checking to make sure that they're aware that they have to do it. This is not something that employers have to do. This is very much the responsibility of each individual EU national. So to actually apply for pre-settled or settled status, it's an online application. As I said before, it's free. It's reasonably straightforward. You just need a phone. When this was originally set up, you could only use an Android because Apple were refusing to give the Home Office access on the basis of privacy grounds, but they've now agreed with the Home Office that individuals that have got iPhones can also now make the applications online. So you basically just need an Android or an iPhone 7 or above. You go online, you create your own account by providing some personal information. You take a photograph of either your EU passport or your EU ID card, and you upload these documents to the Home Office, and you provide details of your national insurance number. Now, if you've been here for 5 years or more in employment, continuous employment, the application should be processed really quickly. The Home Office basically goes straight to Revenue and Customs and asks to see a copy of the individual's economic activity. And if it can be shown that the individual has paid their taxes and national insurance for a consecutive 5-year period, they'll pretty much be granted settlement straight away. It's no bells and whistles document. All they'll get is a notification via the form of a letter saying that they've now been granted settlement under the EU settlement scheme, and they have freedom to live and work here for as long as they like. If it's a more complicated application and you're applying for settled status on the basis that you came here originally as a student, then you had a break in your studies, then you did a bit of part-time work, then you went back to being a student, then you were unemployed, then you got a full-time position, there will be breaks in your economic activity, and the Home Office may write back to you and ask for additional documentation. And in that respect, if they do, it will be evidence of residency rather than economic activity. So they'll ask for things like bank statements, utility bills, any official correspondence you've had over the last 5 years. private insurance cover that you may not have, tenancy agreements, that kind of thing. So it's basically to be able to show to the Home Office how long you've been resident in the UK. For those that have been in the UK for less than 5 years, then it's even more straightforward. They literally just have to make an application for pre-settled status. And all they're saying to the Home Office is, I arrived in the UK in 2020. I'm exercising my treaty rights under the old rules. I'm applying for pre-settled status. Please process my application. And the Home Office will process the application and write out to the individual saying, we've granted you pre-settled status and you will be eligible to apply for settled status once you've resided here for 5 consecutive years. And again, it should be very straightforward, going forward, if the Home Office don't change the rules. Okay, so in terms of right to work checks for your European nationals, at the moment, you can still accept ID cards and passports until the 30th of June 2021. There is an online checking service where you can confirm whether a candidate has settled or pre-settled status. However, at the moment, your employees don't actually have to give you access to their online Home Office account. I can't see a reason why they wouldn't, but if they think, for privacy reasons, they don't want their employees to know that they have this status, then they can actually refuse to give it. And given that you've probably got a copy of their passport or ID card on file anyway, it's not going to be a requirement. It's just something you need to think about come the 1st of July. And then obviously any EU or Swiss nationals entering the UK from the 1st of January this year must obtain a visa to work in the UK. And I'll take you through that requirement a little later on. So let's talk about routes of entry into the UK. So you've got your skilled worker sponsorship route, which is the old points-based system that the Home Office had in place. The new system came into effect on the 1st of December. Now, quite frankly, it's exactly the same as the old Tier 2 sponsored worker route. It's the same points, it's the same qualifying criteria. The Home Office have basically just rebranded it, and we've taken the view that they've done that from a PR perspective rather than for anything of substance. There's another route that doesn't require sponsorship, which is called the Frontier Work Permit route. Now, this is to enable EU nationals who live outside the UK, who have worked in the UK before the 31st of December, periodically, so a couple of days a week. They're normally resident in their main country, but they come into the UK a couple of days a week to carry out a role, and then they go home. If you have anybody within your business that's been doing that over the last number of years, then you can apply for the Frontier Work Permit scheme, or they can. Again, it's an online application and it's free, and it enables them to continue working in the UK on a periodic basis. There are temporary worker routes for sports, arts, entertainment, typically for things like actors, dancers, musicians, film crew, sports people. Not a category that you're going to come across very often. Religious workers, international agreements. There's a category for innovators if they want to set up and run a business where they think that they've got something that's different from anything else on the market. I don't know, for instance, finance, tech startups. They have to be approved by an endorsing body. You've got your investor visa, where if somebody's got a spare 2 million, they can obtain an investor visa and come into the UK. It's a route that leads to settlement. There's a global talent visa, where if you think you're a leader or potential leader in academia, research, arts, digital technology, and you think that you can, be such a leader globally, then you can apply for that visa. But again, getting endorsement from an approved body. There is the Tier 5 Youth Mobility Visa. This is the old Commonwealth Working Holiday Maker visa. If you're aged between 18 to 30 and you're from specific countries, you can apply for a two-year youth mobility visa, which will enable you to work for anybody without sponsorship. So you may see a few of those. And most exciting of all is the graduate route, which is opening up in the summer of 2021. Now, the graduate route is, I suppose it's the old post-study work route. So the Home Office have put this back in place. And basically what it means is that anybody that graduates from the summer of this year can apply for either a 2-year visa if it's under PhD graduation, or 3 years if you're a PhD graduate, to live and work in the UK. So this gives graduates the opportunity to find gainful employment. So it enables them to compete with UK graduates for the limited number of jobs that are out there. It doesn't require sponsorship, so it may be something that would be of interest to you, because you basically get to try before you buy, and you get to select the best and the brightest of the graduates that are out there. So we're quite excited about this. How it's going to operate, we don't know, because obviously it depends on, you know, universities reopening, and then of course how they're running the graduate program, because, you know, we've got graduates from last year that haven't actually graduated yet. But we'll keep an eye on that, and as and when any additional information is communicated to us by the Home Office, we'll let you know. But I think that's definitely something for employers to make use of going forward. Other routes of entry into the UK that don't require sponsorship are UK ancestry. If somebody's got a UK-born grandparent, they can apply for a 5-year visa under that category. You've got students, obviously, where you can employ them on a part-time basis, depending on the restrictions put down on their courses of study. And then, of course, you've got spouse visas. So if you've got anybody that's a spouse of a British citizen, a sponsored worker, a student, a tier 2 migrant, they, of course, can live and work here without restriction for the duration of the visa of their spouse. So that's another visa category that may come across your desk when you're looking at CVs of candidates. I suppose the biggest question you always ask is, do you need sponsorship in order to take up employment with us? And then that determines whether or not you're even going to select the candidate. But something to bear in mind. So let's talk about the main points-based system that's now come into force on the 1st of January. So there are 2 categories under this for businesses. There's the skilled worker route, which is where you're looking to sponsor overseas nationals to fill a permanent position within your organisation. There's the intercorporate transfer route, where if you're part of a multinational organisation and you have global offices, this route into the UK enables you to bring people in on assignment, not to fill permanent positions, but to work within the UK organisation because of the proprietary knowledge and experience you have of that organisation. It doesn't lead to settlement, the intercorporate transfer route, because the idea is you're coming over, work on assignment, then you're going back to your main country of residence to resume your career with the organisation. However, with the introduction of the new immigration system, if you bring somebody in on an intercorporate visa, you can, if you would so choose, switch them into a permanent visa category later on. So you could switch them into the skilled worker route, which is a category that leads to settlement. Now, previously, this wasn't permitted. There was a cooling off period when you had people here on assignment, and if they left, they couldn't come back for 12 months. Under the new regulations, that's been scrapped completely. So it does give you an opportunity to transfer overseas personnel into the UK. And if they like the organisation and you like them, you do have the opportunity to employ them on a more permanent basis. In order to sponsor people, companies must hold a valid sponsor license. It's within the sponsor management system, and a sponsor license is owned to you as an individual. You take ownership of the sponsor license. Nobody else has sight of that apart from you and individuals within your organisation. And the Home Office work with you as a licensed sponsor holder. In addition to the skilled worker route into the UK, or the points-based system into the UK, there are minimum pay and skill levels that must meet Home Office requirements, and there are also occupational codes of practice that the Home Office set down for every industry. So when you're looking to sponsor someone, you've got to look at the salary, the code of practice, the qualifications that they've got, amongst other things. Now, under this skilled worker route, it's 70 points. So you're looking at accumulating the necessary 70 points in order to make sponsorship for permanent positions. And under the intercompany transfer route, you only need 50 points. Within the intercompany transfer route, there are two subcategories. So there are people that you want to bring into the UK on long-term assignments, which you can have up to a maximum of 5 years. They have to be paid a minimum of £41,000 per annum, or the relevant salary set down against the code of practice for the role that you're bringing them in. And then there's the graduate trainee category, where you may have somebody that you want to bring into the London office or the UK office to train them up into a junior management position. Because it's a graduate role, the minimum salary for that would be £23,000 per annum, or the relevant salary set down against a graduate trainee occupational code of practice. Okay, so I'm going to give you an example of the types of salaries you'll be looking at when you're looking to sponsor a skilled worker. So the job offer has to be at a regulated qualification framework of level 3. Previously, the role had to be at graduate level or above, not necessarily the candidate, but the role. And this has been lessened by the Home Office. In order to get your 70 points under the skilled worker route, which remember is for your permanent positions, you get 50 points from attributes. So the attributes are the role itself, and potentially whether or not it's graduate level, or obviously the salary and the academic qualification. And then the other 20 points that you need is to meet an English language requirement and to show that you as an individual have sufficient funds to support yourself when you come in under the skilled worker route. Now, English language is something to bear in mind with our European friends, because obviously they won't be used to the fact that they now have to get sponsorship, and they're going to have to show that they have a degree that's either equivalent to a UK degree taught in English, or they'll have to sit and pass an English language test. The salary that you need to offer has to be not less than £25,600 per annum, or the applicable salary set down on the code of practice. If the role you're offering is a shortage occupation, then you can pay less, and you'll see that the salary is £20,480. If you're under the age of 26, studying, or a recent graduate, then obviously the salary is slightly less as well. And if you're doing a role in a PhD position, then you can pay a salary of £23,040. Obviously, you'll assess the role and salary for each individual case that you're looking at in terms of sponsorship. Within the skilled worker route, there's two categories. So you get a certificate of sponsorship, which is basically your work permission. And they're either defined applications, which are for skilled workers applying for entry clearance or visas from outside the UK, or they're undefined certificates of sponsorship, where you're looking to sponsor somebody that's already here. So an example would be if you wanted to offer a role to somebody who's already being sponsored by another company. But you've decided you'd like to headhunt them and sponsor them for a position within your organisation. Providing you've got your sponsor licence, you can apply for what's called an undefined certificate of sponsorship, saying to the Home Office, we've identified somebody that we would like to sponsor. They're currently already here working and we want to steal them. Please provide us with an undefined certificate of sponsorship. And once you've got that, you can start processing an in-country application. With your defined certificates, this is where you submit a request to the Home Office on a case-by-case basis, saying, I've located somebody in Canada. No, I won't use Canada because they can get Tier 5 visas. I've located somebody in the US whom I would like to sponsor for a permanent role. You tell the Home Office about the role that you're offering, the salary, the working hours, and you submit that request via your sponsor management system. The Home Office, if they're happy with the information provided, are supposed to allocate that certificate of sponsorship to you within 24 hours. Sometimes it works within 24 hours, sometimes it doesn't. I would say factor in a 5-day working period. But if you're granted your defined certificate of sponsorship, you can then progress the application and assist the overseas national with their visa. And then once their visa is granted, they can come on into the UK and start working for you. So, codes of practice for your particular industry, they're always based on a 39-hour working week when we're calculating the salaries that you need to offer. So for architects, generally speaking, it's £35,000 per annum or £17.26 an hour. So if you do a 45-hour working week, you calculate the minimum salary you have to pay based on the hourly rate. However, the good news is because architects are currently in the shortage occupation category, we can calculate 80% of the going rate, which is £28,000 or £13.81 an hour. So to calculate what you'd need to pay to sponsor somebody from overseas to take up a role as an architect for you, you do your £13.81 an hour times your weekly working hours times 52, and that will give you your minimum gross salary. For quantity surveyors, the minimum salary against this code of practice is £30,600, and again, £15.09 an hour. For chartered architectural technologists, you'll see the salary there of £27.09 and the hourly rate. And then for construction project managers and related professionals, which is a catch-all for all sort of project management roles within the industry, £28,700 or £14.15 an hour. So that kind of gives you an overview of what you'd be looking at if you're looking to sponsor somebody under the skilled worker route. So in order to sponsor your overseas workers, you're going to have to apply for a sponsor license. It's an online application process. You have to demonstrate that you're established in trading and provide some supporting documentation. As part of the process, you have to nominate what's called an authorising officer. From within your organisation who is the person who's responsible for managing your sponsor management application, and provide them with level 1 access so that they've got access to the system. Now, the role of the authorising officer is extremely important. They are the face of the organisation for the Home Office. So when you apply for the sponsor licence, ordinarily you would have gotten a pre-licence visit by a compliance team from the Home Office who will come in and have a look at your HR functions and systems and processes. And the person that they want to talk to about that will be the authorising officer. So it needs to be somebody who is generally considered the most senior person within your organisation, responsible for the recruitment of all migrant workers and the person responsible for ensuring that you meet all of your sponsor duties. It is for you to determine who would be the most appropriate person to hold that position. Generally, we usually suggest somebody within HR because they're usually fully conversant with recruitment practices, hiring, firing, etc. And because it's a compliance role, it's important that the authorising officer is aware of the movement of staff in that respect, because there are reporting duties and responsibilities that the authorising officer needs to be aware of. When you're applying for your licence, if you have multiple branches or offices, you can add as many linked entities as you want. So for instance, Sainsbury's have a sponsor licence, and of course they've got branches all around the United Kingdom, and all of those branches are known to the Home Office on their sponsor licence. So if you have a head office in London and subsidiary offices based around the UK, at the point of applying for your licence, you can name all of the linked officers so that when you sponsor somebody under the skilled worker route or bring them in on assignment, you have the facility to have them working at any of your office locations. providing the Home Office know that you have those locations. When you're applying for a sponsor licence, you need to decide how many overseas nationals you think you might need to sponsor in your first year. And you need to ensure that you're providing all the relevant supporting documents to the Home Office within 5 days of submitting your online sponsor licence. I'm not going to go into a huge amount of detail about what's required. This is just kind of an overview. And then if you do decide you want to apply for a sponsor licence, because the talent pool is so much less, we can arrange separate conversations about the nitty-gritty of what's required. As I said before, you've got to show that you're a genuine organisation operating lawfully in the UK. You've got to show that you can offer genuine employment, so you need to show that you're not displacing any resident workers. You have to be able to show that you're capable of carrying out your duties and responsibilities in terms of compliance. You have to show that you've got established HR processes and recruitment practices in place. Now, this is typically how you monitor your employees. So in terms of keeping copies of relevant documents to show that your employees are lawfully able to work for you. When do you ask to see these documents? How do you record them? Information records on employees' attendance. So how do you know somebody's actually at work and doing the job for which they're being paid? Contact details for your employees. How do you make sure that they're up to date? If somebody moves address, do you keep a record of that? Do you keep it historically? Those are the kinds of things that the Home Office will be looking to see from a compliance point of view. If your sponsor licence application is successful, you'll be granted a licence for 4 years. The fees are determined by the size and turnover of the organisation. So if you're considered to be a small organisation, the Home Office fee is £536. If you're considered to be a large organisation with a turnover of more than 5 million and more than 250 employees, the fee is usually 1476. In terms of the fees, just as an aside, you might be a small organisation in the UK, but you may have a parent company that's massive, which has global subsidiaries. And in that case, turnover is likely to exceed 5 million, you'll pay the higher fee for the sponsor licence. Okay, so compliance checks under sponsorship. You have to show that everybody has the correct work permission before commencing work with your organisation. Now, that's been in place since February 2008, so you've probably already got those policies and procedures in place. You have to notify the Home Office of any changes to the company's circumstances or changes for your sponsored workers. So, for instance, if you apply for a sponsor licence and your head office is in London, and that's the only office you have, and then you decide that you're relocating the London office to Scotland, then you have to tell the Home Office. If the Home Office came out to do a post-compliance check on you and they went to your old London address and you were no longer there, you would automatically have your licence revoked. If there are any changes to the company's organisational structure in terms of ownership, etc., again, you have to tell the Home Office. The changes have to be notified within a specified time frame. Obviously, you have to keep specific documents relating to sponsorship on personnel files. And of course, there are penalties for non-compliance. The biggest penalty, obviously, is the revocation of your sponsor licence. It would mean that anybody you were sponsoring would have their visas curtailed. You wouldn't be able to sponsor anybody else for a significant period of time. Bad on the company reputation, and the authorising officer could leave themselves open to a civil penalty personally, and, you know, in a worst case scenario, imprisonment. Where that would occur would be if I decided I was going to do a bit of people trafficking using your sponsor licence, and I'm issuing fake certificates of sponsorship to people and then just pocketing the money. If it comes to light that I've been doing that, well, not only would I obviously have severe consequences imposed against me and probably lose my licence to practice and be sent to prison, so would the authorising officer. It's never going to happen, but it's something that, you know, the authorising officer and the company need to be aware of. It's really important that companies take compliance really seriously. You'd be surprised at how many times I get notified by my clients that they moved addresses 4 years ago and didn't tell the Home Office, and they've got sponsored workers. And not only do you have to tell the Home Office that you've moved physical locations, you have to tell the Home Office if the place where the individual you were sponsoring for work has changed. So it really is quite important to make sure that compliance is taken seriously. Okay. Now, the Prevention of Illegal Working legislation came into force on the 29th of February 2008. So it made it a statutory offence to employ anybody if you hadn't seen an original document to show that they had the right to work. So the penalties for non-compliance are quite severe. So you can see up to 5 years imprisonment, £20,000 penalty for every unlawful person working in your establishment. So if you think about restaurants and hotels and the Home Office compliance officers raiding these organisations, where they find undocumented workers, that establishment is fined £20,000 for every undocumented worker. Obviously, seizure of earnings made from any illegal working, and the ability to employ and sponsor workers, and ultimately the closure of your business. Bizarrely, I know of a number of restaurants that have been raided and they have been fined for non-compliance in terms of illegal workers, but they haven't been shut down. I think personally it's probably the Home Office thinking that it's a bit of a money earner for them, and they can just you know, slap them with a number of fines and then keep an eye on them and then raid them every couple of years just to earn a bit of income for the Home Office, but who knows. So your responsibilities for the right to work checks are that you must check original documents are genuine and consistent against the details of the document that you're being seen. Obviously with COVID, that's impossible now. You know, even if you're hopefully you're still employing people and recruiting people. So because of the fact that we've got this pandemic and everybody's being asked to work from home, let's say for argument's sake, I'm going to join you on Monday. And I can only ever show you now my documents electronically. It is acceptable for us to have a Zoom meeting or a Teams meeting, and I will hold up my passport for you to have a look at. Now, normally I would take my original passport or ID card to the company on my first day of induction, and you would copy it and you would sign it saying original seen, put the date that you saw it, and shove it in my personnel file. Now, because we can't do that, the Home Office are allowing you to state on the document that you've seen, and this is something that you need to write on the document. So I send you an electronic copy, and somehow you need to print it off and write on this that it's an adjusted check undertaken on a specific date due to COVID-19. So it's important that any documents that you've seen since we were locked down and on the 23rd of March last year, basically, so anybody that you've employed where you've had to check their original documents, put this adjusted check undertaken and put the date that you undertook it, and then put that in the personnel file, and the Home Office will accept that as a statutory excuse for the document that you've checked. This policy will revert back to having to see original documents once we're out of lockdown, and then freely able to go back to work in offices. I think Boris announced on Monday night that he was hoping that everybody would continue working until at least June remotely. So for the time being, it's in a COVID adjusted check, and then you'll go back to asking to see original documents once the world goes back to normal. You must check the document before a person starts work. It's not sufficient for you to say, well, the agency saw the documents and they're happy that, you know, the person had the right to work for us. It's your responsibility as an employer, not an agency. So you have to be able to show that you've checked that document. are you allowed to check a document that's got an expiration date? So for British passports, actually, yes. If somebody's got a British passport, then they're British nationals, and they don't necessarily have to provide you with an up-to-date British passport. However, for those that are on visas that have expiry dates, then you must ask for current documents. So current passports, current biometric residence permits. The way you secure the documents must be in non-alterable formats. So PDF electronic documents are absolutely fine. And obviously you've got to record the date you did the check. If you're potentially looking at sponsoring somebody and you're not quite sure whether their immigration status gives them the ability to work for you without sponsorship, or indeed if they have a pending application with the Home Office for, let's say, settlement. So I've been living here for 5 years as a Tier 2 sponsored migrant, and I've recently applied for permanent residence on this basis. And you want to employ me, because my application is pending with the Home Office, my immigration status is automatically protected. So you can go online to the employer checking service and you can type in some details about me and you can ask the Home Office if you're entitled to employ me. What you will get from the Home Office is a positive verification notice that says, yes, Katy is lawfully here and she is eligible to work for you, and it's valid for 6 months. If my application hasn't been approved by the Home Office within that 6-month period, you can simply go back onto the employer checking service, submit another request for a positive verification notice, and continue doing that ad nauseum until such time as I can come to you and say, I finally got settlement, I have no employment restrictions, and you put those documents on my file. A useful tool if you're talking to somebody who's not sure whether or not they can actually work for you. Okay. The right to work checks, you can't delegate these to a third party. This is something that you have to do in-house, and I'm sure you're all doing it already. Normally, as I mentioned, it would be done in the presence of the holder of the document, but obviously you can do it via video link until such time as that changes. You're not supposed to be experts in false documents. So it's just got to be your best guess in terms of, does it look like me? So when it's going to be a difficult one, because when you're holding up a passport with a photo of somebody, that photo could be, 9 years old and the person could have changed significantly. So, you've got to be reasonably satisfied that it is a genuine likeness of the person. I mean, I travelled a few years ago, and when I was coming back through immigration, I was most offended because the immigration officer didn't actually think that the photo was a true likeness of me. And it took me a good 20 minutes to, tell him that where I had been travelling had changed my the way I looked significantly, but eventually he let me back in. So, it's just showing that it's reasonably apparent. The eyes never change, and neither do the earlobes if you're really interested in scrutinising somebody's photo that much. So there's no statutory excuse against checks that are carried out by an agency. If you believe the documents are false, or the individual doesn't have the right to work, you don't have an excuse against that. I mean, it's the obvious things. Assuming that somebody sends you an academic qualification from Nigeria and the font is in, 5 different fonts, and it's clear that the university doesn't exist, you can take that as, and you haven't bothered to check it with the university, you can take it as read that that's a false document. And then it's got to be reasonably apparent that the document presenting the document isn't that person. So, it's got to be clear that the photograph I show you is clearly of a man and not of, a female. So, you just got to you've got to be pragmatic when it comes to the document checking. So that's pretty much an overview of where we are at the moment. Obviously, as in things things change going forward, we'll keep everybody apprised. But yep, that's where we stand in the COVID year of 2021.
Thank you for that, Katie. And we actually did have a few questions come in. We've got a few about the right to work checks. You may have sort of covered this in your last couple of slides, but in terms of those who already are employees at your practice, what sort of checks do you need to do for them? Is it the same process or is it something different if you've already got them employed?
No, if you've already if you've already checked their documents, then it's a one-off exercise. You don't have to do it again.
Okay, and another one was sort of what do you think the process will be for those businesses who remain remote going forward if they don't sort of choose to go back to, you know, an office situation in terms of the, you know, you talked about the right to work checks being all remote right now, but then it will change once COVID sort of want to go back to normal. What will happen then if businesses choose to remain remote? Will they still have to, you know, meet face to face and show the proof of these documents, or will there be a new process, do you think?
I think, yeah, that's going to be a new way of working. And I think that you've got to look at that in terms of induction processes, to be perfectly honest. So going forward, if you have no intention of ever going back into an office setting, and you carrying out your inductions remotely, then, you know, yes, we would expect you to do the document checking remotely as well. And we would also expect the Home Office to be fairly relaxed in terms of document checking remotely because of COVID. And we expect them to be able to state that, you know, where you are no longer in an office setting and you work remotely, then you can continue carrying out remote document checking. You'll just remove the COVID bit, to be honest, and you'll simply say document checked electronically on this date, and then put that in the personnel file. So I don't see any issues with that going forward.
Okay, and then a few other questions about sort of the student and graduate routes. One is, what category and SOC code do you use for Part 1 students that you would like to sponsor as a skilled worker? And do they also fall under the shortage occupation that you discussed?
Is this for the architects?
Yes, so Part 1 sort of entry-level architect.
Yeah, I mean, they've removed the, I mean, under the old system, they did have Part 1, 2, 3, qualified, etc., but they've actually removed that. So you're kind of looking more at the technologist sort of route, or if they're under 26, obviously you can pay them the lower salary.
Yeah.
And they're not a qualified architect per se, so they won't fall under the shortage occupation. But if they're graduates or it's a sort of trainee position, then there will be a lesser salary that you can look at.
Okay. And is the graduate route applicable for all countries internationally? Sorry.
No, this is for graduates in the UK.
Okay. We've had a few others just come in now. One is there a cap on how many sponsors a company can have? They've given an example, sort of case study. We're looking at hiring an Irish national who has a married Scandinavian partner. Would the partner be able to come with the Irish national if they are married?
Yes, the partner of the Irish national would obviously, you know, hopefully formalise their status to show that they're a spouse of an EU, because obviously there's different rules with Ireland.
Mm-hmm.
And then, you know, yes, she could definitely come in. And I mean, my sister is married to an Irishman, and she obtained an Irish passport, but they take forever. So yes, I think there will be concessions for that. I can certainly look into that if you like.
Okay, well, I think that's sort of all the questions that we've had through. A few people asking about particular slides and if they can receive a copy of the presentation, but I will get in touch with me if you would like to receive a copy. We have also recorded the session, so it will be available. We'll be doing a write-up on our website for you all to read through. But thank you again to Katy, and thank you to you all for attending, and I hope you enjoy the rest of your day. Cheers.
Thanks very much. Pleasure.